North Carolina has strict and progressive domestic violence laws. It is important to understand that North Carolina has both civil domestic violence laws and criminal domestic violence laws. The requirements and results depend upon which avenue, civil or criminal, is pursued by a victim of domestic violence. Chapter 50B is the shorthand term for the statute that governs civil domestic violence in North Carolina. You have likely heard about a restraining order, which is commonly granted to a victim in a civil domestic violence case. After reviewing the application for a domestic violence protective order, known as a DVPO, a judge can order the offender to leave the residence, not come around the victim's work or school, and even grant custody and support. However, the court first has to find, based on the application, that the alleged offender has caused harm to the victims or attempted to do so, and that the victim and alleged offender have had at some time a dating or intimate relationship. The initial order granted to a victim can be granted by a judge without notice to the offender. The offender will then be served a copy of the order with the return court date and the restrictions and restraints imposed on the offender by the order. At a hearing, the judge has the right to continue the order in effect, modify portions of it, or dismiss it entirely. A person who is served with a civil domestic violence order is not placed in jail for any period. He or she is merely served with paperwork notifying him or her of the date of the hearing. However, after the offender has knowledge of the order, then he or she can be charged criminally for violating the civil domestic violence order. If someone is charged criminally with domestic violence in North Carolina, only the state of North Carolina can draw up the charges, not the alleged victim. Another big distinction between the civil and criminal domestic violence laws is that a criminal defendant will likely be physically arrested, taken to jail, and sometimes remain in jail for up to 48 hours, depending on the size of the city or town. The victim of domestic violence should not assume that the alleged offender will be in jail for the full 48 hours, but should check with the arresting law enforcement agency, as the offender may be freed from jail under certain circumstances. Potential punishments in criminal domestic violence court range from probation for the first-time offender who is likely charged with a misdemeanor to years in jail for an offender who causes serious injury.